The entire challenge projected by the petitioner is on the ground that the respondent 4 has not met the eligibility criteria. The eligibility criteria have been laid down in section 5 of the tender document. The primary requirement is that the participant is required to have at least 3 years experience in providing medical care at community level. There are also other requirements, namely bidder should not be blacklisted, to provide balance sheet for 3 years, and to have certain annual turnover for the last 3 financial years. It is not the case of the petitioner that any of the aforesaid eligibility criteria have not been fulfilled by the respondent 4. The projection has been made on the numbers of MMUs, which, however, is not a part of the requirement under the eligibility criteria. In any case, marks were allotted in the technical evaluation, and the NIT stipulated that if the bidder secures a certain minimum marks, the bidder would be eligible for financial evaluation. In the instant case, the respondent 4 had secured 24 marks out of 30, which is more than the minimum prescribed, and therefore was eligible for the financial evaluation. Since this court has already come to a finding that the eligibility criteria do not lay down any requirement with the numbers of MMUs, a challenge made on the ground of possessing certain number of MMUs is not tenable either in facts or in law. With regard to the second submission of there being minimal difference in the price, the said submission is also factually incorrect, as the difference has been shown only on a monthly basis, whereas the actual difference in the total price would be about ₹3 crores. Therefore, there is immense public interest involved in the process, and in fact, public interest is being protected by the decision taken by the respondent authorities. In view of the above, the requisition stands dismissed. Record the return back. Green file. Ready to look correction as return. There are some corrections, we will have it later. Yes.
There is two matter. One is motion in the admission. It is maybe listed on Monday.
Which item?
My lord.
Which item?
No, my lord, new item.
Code number 4. You have to mention code number 4.
Listing civil bench for
Yes.
May I please, your lordship, with the consent of other side, lordship, item number 16, 17, and 18, lordship. Here in this matter, lordship, I could not appear for the petitioner. I have taken the consent, lordship.
Which are these matters?
16, 17, and 18. Lordship.
Hearing matters.
Yes, lordship.
Hearing today perhaps it will not be possible because this court will not be there for 2 weeks.
Lordship.
There are some unfinished works. We have to rise early. Second half, we have to, only for a judgment, there is a judgment, we have to
Lordship.
2 o'clock. Otherwise, we will not take up hearings today.
17 and 18.
We will not touch.
Okay. Oblige, your lordship.
If you want, we can pass on. Oh, no, it's a 12 matter. We will not.
Lordship.
it will come automatically.
Yes, yes.
Oblige, your lordship.
May I please, your lordship? Lordship, I beg to mention item number 15, my lord.
15.
15, my lord. Though I am not signatory of Kuala, my lord, I have read the instruction from the petitioner side, my lord.
For 12 matter, we would not have touched,
No,
but
my
would
lord, this matter became actually
infectious. What is the matter about?
Lordship, in this case, one order 10 May 2012 was challenged, my lord, regarding use of plastic product, my lord.
Okay. Sri Hazarika, learned.
M. Mohan, my lord.
Sorry, Sri M. Mohanta, learned counsel for the petitioner. No, you're not there actually. No?
But
Sri M. Mohanta, learned counsel on instruction of who is there? Any council who's there?
Well, Lordship, earlier council, Milord,
M. Burman is there,
Lordship,
in the court,
Lordship.
on instructions?
Even I took instruction from, petitioner.
No, you are not on record.
Government advocate whether.
Okay, on instructions for his senior,
Lordship.
Sri P.K. Goswami, senior counsel, submits that the matter has become infructuous. Also heard, you may be,
Mala.
not her,
Not me, my lord.
he has changed side,
Yes.
his loyalties. Not good. Also heard, M.S.S. Sharma, Tennessee State Council, where the GMC is represented by any GMC council?
Yes, Lordship, I'm here.
Oh, Mr. P. Nayak, full stop. The repetition accordingly stands dismissed as infructuous.
The hearing item number 26, one of the.
Hearing today, it may not be
A
possible.
date may be fixed after 2 weeks, one of,
He'll give a date.
and a date be fixed after.
He'll give a date. Case of which year?
No, that matter, my lord, that gunshot injury matter, my lordships were
Oh.
taking up that matter. The date it can be fixed, so
Gunshot, this was,
towards the end of May, perhaps. My lord.
why was this adjourned?
No, they had to take instruction on that FIR which was pending in the Tezpur PS. That FIR relating to the mob violence, whether I was a part or not. Because one of the requirements of the notification was that I have to be innocent to be entitled even to the notification.
No, that part, I think we had arrived at some satisfaction.
What I, my
There was
instruction from the
some
petitioner is,
other consideration. Why was the time given?
oh, that FIR status, my lord, Mr. Deori was there.
I think the status of the FIR only.
Yes. Let it come up in the
Uh,
end of May, Lordship will take it up perhaps.
But this will not take much time. This perhaps we could have taken if they are equipped with the instructions.
No, I have one difficulty, my lord. The petitioner has instructed me that he was also disabled and he has a disability certificate which is not on record.
You want to bring it on record?
Yes.
Okay. Then we'll not say anything
Lordship,
in the meantime.
towards the end of May,
Uh,
perhaps.
Adjourning will not be proper because there is no prayer for adjournment.
Lordship.
Can we record your submission that there is development you want to put it on record? Sri A. Ganguly, Learned Counsel for the petitioner submits that though this matter is of the year 2017, recently the petitioner has informed him regarding some subsequent development which would have a bearing, which may have a bearing in the adjudication of this case. Full stop. He accordingly prays for and is granted 2 weeks' time
2 weeks.
to bring on record the efforts and development by way of an affidavit,
Lordship.
least after 2 weeks. Other side,
Lordship, item number 10 to 13, Lordship.
yes.
Your Lordship fixed this matter today for disposal. But Lordship, my difficulty is that when I ask for instruction, Lordship, no record is available in the office, Lordship.
These are the Boston matter.
Yes, Lordship.
We have heard this matter. This is,
And the 11th, that is appearing. Number of as item is.
No, Lordship will say item.
That may be all for Lordship. Necessary. That may be all for.
why records are not
No,
there?
Lordship, today what they are doing, Lordship, with the district administration, they are going for an inspection, Lordship. And they are trying to calculate, Lordship, what is the actual liability of the GMC, Lordship.
2009.
We'll fix a date there. We'll fix a date immediately after 2 weeks.
Lordship.
You get the instructions, whatever. Sri P. Nayak, Learned Standing Council, GMC, submits that though he was directed to seek instructions, the records being records pertaining to the year, pertaining to the year, which were here,
2009.
not 9, it is prior to that.
2007 matters are also there.
7 also there.
The records being of the period prior to 2009, the same could not be readily traced out, full stop. He accordingly prays for and is granted 2 weeks' time to obtain instructions, full stop, para. However, considering that this writ petition is pending since the year 2009, registry to list this case on
Hearing
on 23rd May.
Lordship, may I pay Lordship a copy to prepare a copy from the court's order, record, Lordship?
Difficult.
Only the petition and the affidavits. Lordship.
You have it from the.
He has only one copy, Lordship. He gave me yesterday. I took a photocopy from that, Lordship. That so far as 2009 is concerned. Other matters, Lordship, no record is available with me also.
It is not permissible.
our copy have given.
You don't have other copies.
That 2009 matter, Lordship.
9 years.
That I have got, Lordship.
Then what else do you need?
Remaining Lordship petition.
10 to 11 to
2007,
14, my lord, will
11 to-
appear.
You please give a copy.
Next time, ঠিক আছে, এই করে দিন।
Please enable him because it's not permissible actually,
Okay.
unless you apply for a certified copy.
Lordship.
Next is your lordship. Your lordship, mention item number 25. And along with the 25, 24 is also tagged with your lordship. Lordship, wasn't pleased to direct that the matter may not be placed before your lordship by operated 1912. This 1912-22.
It's gonna, this court had appeared as a council or what?
That, but your lordship was pleased to direct that the lordship to place it before any other bench, your lordship.
Court, so?
1912, your lordship. But somehow the matter is again.
That council is it, huh?
Lordship was a perhaps forest council,
That is, court had appeared as a council or what?
my lord, perhaps in.
No, he's not aware. Well, let us see. 15 matter most likely. Here it will, 1357.
Probably ABC infrastructure, it is a
1912.
It was also heard. And CAV, then released from CAV. Why? 1912 what?
1912 is the order dated,
1912,
22, your lordship.
22.
Yes,
There's no such order.
24 and 25.
What is it? Bill- উল্টা পুল্টা হয়েছে এরকম কেউ ওটা সেটা নেই
Rakesh Singh versus State of Assam and one is ABC Infrastructure versus State of Assam. 1912, no?
এটা আসছে না 1890 ভেরি বিরাট উল্টা পুল্টা হয়েছে 21 yes this code লেখা আছে not by not by 19
12.
2022
Yes, your lordship. Maybe then the other case,
পরে কিছু আছে নাকি আবার
Rakesh Singh versus State of Assam.
there is no such order but we cannot take up you are correct we had appeared
Yes, Rakesh Singh versus State of Assam, your lordship. That case,
it was a decision. The order sheet reveals that this court had acted as a counsel in this matter, full stop. Accordingly, it is directed for listing of this court, listing of this case before any other bench.
oblige, your lordship. May I please, your lordship? Lordship, back to mention,
25 list along with so and so. Yes,
back to mention item 20, your lordship.
20.
Yes, your lordship.
Proceed,
Hearing
Rohit.
matter, your lordship.
Yes.
The senior counsel is not well, your lordship. Is out of Guwahati. And I have taken the consent from the other side, your lordship.
A prayer for adjournment has been sought for on the medical grounds of
HRHO.
H.R. Chaudhary, the senior counsel for the petitioner, full stop para. The adjournment being sought for on medical grounds, comma. The same is granted. And the matter is directed to be listed after 2 weeks.
Oblige.
May I please, your lordship? I would beg to mention item number 21, my lord.
21, yes.
My lord, in this matter, Mr. Albert Habu, due to some personal difficulties, will not be able to appear before his honorable court. The matter may be adjourned, my lord. We have
16 matter, today you are lucky you were not touching, otherwise. On the prayer made on behalf of the petitioner, at least after 2 weeks.
obligement.
May it please, your lordship.
Yes,
Lordship, in this case, Lordship, petitioner's father was killed by unknown Boro extremist, my lord. Police report page 17 shows that, my lord. So government has adopted some policy, my lord. As per policy, the ex-gratia of 3 lakhs, my lord, he has to be paid, but not paid to the, she has also filed a representation page 35 to the Deputy Commissioner Kokrajhar. That is not have been acted upon, my lord. So in this case, my lord, some order has been passed by the coordinate bench of Lord, my lord. This may also be disposed of with direction to verify. If found genuine, may be paid, my lord.
but when was the incident?
Incident 98, my lord.
What did you do all these years?
My lord, due to ignorance, my lord, the lady, my lord, even my lord, in
From 98, you could wait till 2023.
poem has been issued in 13.
So there was no law at that time.
2000,
By the existing law,
my lord, there is the OM, my lord.
did you come in 2013, 14, 15, 16, 2023? Who to dismiss it on the ground of delay? Arts Sri Amar Khandakar, Learned Counsel for the petitioner, who by means of this application has prayed for a direction for payment of ex gratia on account of the death of our father.
Even my lord, last order, my lord, I was asked to submit MOK, my lord. It has been applied, but not.
The death, the record reveals hard bully করো নাকি? Hard question. Also hard. Who is appearing for the government?
2, 5, 6, and 7, my lord, I have.
Also heard Priya Bhattacharya, Learned Standing Council, Revenue Department, MSS Sharma, Learned State Council for the state respondents. Madam, you're also there?
My lord, I am appearing for respondent 4.
Who's
On the BTR, but.
and MSS Chutia, Learned Standing Council,
Oh, my lord, on behalf of.
Learned
PNR.
Council on behalf, appearing on behalf of the BTC. Full stop. Then you write this, huh?
My lord, may I say to withdraw, my lord?
Okay, will it, however, the record reveals that the death was in the year 1998. But there is no explanation whatsoever with regard to the delay of about 25 years in approaching this court. Full stop. This court being a court of equity cannot entertain petition of this nature. Full stop. But at this stage, Common Learned Council begs to withdraw this writ petition. Full stop. Writ petition accordingly dismissed on withdrawal. I am on this.
But in fact, the matter was taken up for final disposal. The matter is very short, my lord.
We have heard this on the last occasion.
My lord,
That same matter.
that was the assessment was below bar by limitation. The lordship can see that the matter is very short. But the assessment in this case,
There was another matter. Oh, we have heard the
Completion.
Okay, not this one.
This one.
Okay, okay. This is a separate matter. Yes, what is this?
So the assessment relates to assessment year 9-10. Now, as per the act, my lord, the assessment has to be completed within the period of 5 years. Now, the 5 years period expired, my lord, long back, and thereafter the assessment was completed under section 40 of the act. Now, we'll also make see section 40 of the act, my lord.
এখন দেব।
Yes, see it.
সেলফিটা ফোন এখন। আমার আছে তো এখন। এখন দেখুৱাই দিলে হ'ল। হ্যাঁ, দেখুৱাই দিলে হ'ল না ওলাই দিব। এখন সব বাহিৰ গৈছে আপোনাৰ। ৰেলৱে টেক্সৰ সৰু কিতাপ আছে নে?
You also may take this, my lord. Extra.
We should have a book. কাটালৰখনে। নালাগে বোলে গুচাই দিব লাগে এইবিলাক কিতাপ। Citation-ৰ কিতাপ কিয় আছে দুখন ইয়াতে? মোৰ সৰু কিতাপ আছে তো এইখনটো ডাঙৰ। এইখনটো আছে। কোনটো ইয়াৰটো 2000? ঠিক আছে। লাগিব পাৰে। Which provision you are referring to?
Okay, my lord.
40.
40.
Yes, please.
My lord. Where after a dealer is assessed under section 34, 35, 36, or 37 of this act, or in a year or part thereof, the prescribed authority has reason to believe that the dealer, then a whole or in part of the turnover of the dealer in respective period has escaped assessment and so on. So, my lord, first is that, my lord, the dealer must be assessed under either section 34, 35, 36, or 37 of the act. Now, you'll also may see section 34. That it relates to the provisional assessment,
Yes.
and there was no provisional assessment in the case of the petitioners.
Okay. 34 is out.
Out.
Okay. Yes. Then
Let me see section 35,
35 self.
that is self-assessment.
Hmm.
So let me see the
There.
amount of tax from a dealer
Hmm.
able to pay tax may be assessed separately for each assessment year for which he is so liable.
Hmm.
Provided that the commissioner may subject to the conditions, if any, as may prescribe, assess the tax so and so. After so, if a dealer has filed all the returns and the annual return or the revised return in the prescribed manner and within the prescribed time,
Hmm.
and has paid the tax payable according to such returns or revised returns, also interest payable, if any, the return or revised return so filed shall be accepted and the assessment shall be deemed to have been made for the purpose of section 1 subject to so and so. So, my lord, if the dealer has filed all the returns in time, revised return in time, and has paid the taxes in time, then it will be self-assessed. Now, rule 29 will also kindly see, my lord. Rule 29.
Rules are in this big book.
My lord, rule,
Page.
I'm sorry, my lord. No, my lord, I am not required, lord. This is in the petition, my lord, I've stated that when the returns were filed and the returns were not filed within time, you'll also may see, my lord, at page 5,
Of your petition.
my lord. For April 2009, it was submitted on 12/6/2009. And it has to be submitted within 30 days of the preceding succeeding month below, as per section 29. So you'll also see the April and May, the returns were submitted after the expiry of the period of limitation. Thereafter, you'll also see para 5 at page 6.
The April returns you have to file when?
Well, within 30 days of the succeeding month,
That means by May, this was done on 12/6.
6,
So it was beyond.
beyond the period.
Okay,
Now, May has to be submitted by 36, and it was submitted on 1/7.
correct.
Now, the next, you'll also see the revised returns
Hmm.
at page 6.
Hmm.
Plus, you find April 9, the date of filing of the original return was 12/6/99. And my lord, the revised return was submitted on 12/4/2011.
Hmm.
That is 1 year within the return has to be submitted, and it was not submitted.
Hmm.
So, my lord, the self-assessment as per the provisions of the Act cannot be said to be completed because the returns, it says all the returns must be submitted in time, revised return in time, and the tax must also be paid within time. Since it was not done, the self-assessment cannot be said to have been made.
So you're trying to rule out 35 also.
35 also. then.
Then,
Then section 36, my lord. This is about audit assessment,
hmm,
and no audit assessment was undertaken in the present case, because their case is that it was self-assessed. Their case is that, my lord, it is only self-assessed. It did not say that 36. Now we'll also see section 37,
best judgment.
base judgment assessment. In this case, there was no assessment at all, so question of base judgment assessment does not arise.
Yes.
Now, since the limitation was 5 years as per section 39,
What about the proviso?
my lord, provided in case of offense, only there is no my lord, proceeding under for the offense in the.
Offense has been
No,
alleged.
So the assessment was to be completed within 5 years before the expiry 5 years from the end of the assessment year to which the assessment relates. Since the period expired, the assessing officer completed the assessment, the section taking recourse to section 40 of the Act. Now 40 of the Act can be taken, my lord, only when the assessment has been completed either in the section 34, 35, 36 or 37 of the Act. Now, since the assessment, no assessment was there in 34, 35, 36 of the Act, 37 of the Act, the proceedings under section 40 of the Act cannot be undertaken.
So your assessment was under which section?
Section 40.
No, the recourse they have taken is under section 40.
Indeed, there was no assessment. I submitted the return, there was no assessment at all. So the assessment became barred by limitation under section 39. Now, since it became barred by limitation, the proceedings
You
were,
mean you want to submit that there was no assessment at all?
my lord. And their case is only that, my lord, that the self-assessment
Not only there has to be an assessment, it has to be an assessment under
34, 35,
35, 36 and 37.
7 of the Act,
Those are the conditions precedent to invoke 40.
my lord,
So those conditions have not been fulfilled.
not fulfilled
There are 4 conditions.
conditions, my lord.
Neither, and none of them have been fulfilled.
First is provisional
So you do
assessment,
not come under, you cannot be assessed under 40.
40 of the Act,
And there is a bar under 39.
39.
You cannot go for a fresh assessment after 5 years.
My lord.
That is your case.
Now, the apex court has also said, my lord, that
Mr. Bhuya,
Lordship. Lordship, let the other side complete.
we have understood the case. This is a small matter, very smallish point of law.
Then in this case, can it be taken after some time because council be you guys on legs?
But the division bench of this honorable court also, in the similar cases, my lord.
No, there is no, if you, what you are saying, factually, if there is no dispute,
Their case is only
they
self-assessment.
are not projecting something else on facts, then probably there cannot be any dispute at all.
They have filed affidavit, they said that self-assessment, but without taking consideration of the conditions of the self-assessment. Assessment cannot be there, my lord.
That is where we wanted to come in, that unless you are factually confronted on the issue that 35 is also not applicable. On the, you have said that it was not done within the time period, so that self-assessment, the provisions of self-assessment you have not fulfilled, so 35 will not come in.
Now, whatever chart I've given, my lord, in the petition, that has not been disputed.
That's the only thing we have to ask from him.
Yes.
Other 34, 36 and 37 on the face of it are not applicable. The only applicability which Jay would probably
Section 35.
project is 35. 35, you have said that 35, the requirements of 35 we have not fulfilled, so 35 will not come in. And since there was no assessment earlier, the only provision was 39, which is even become time barred.
And in the similar case, my lord, where the assessment was not completed, this division bench of this honorable court set aside the assessment, reassessment order, that there cannot be any reassessment without there being assessment. Following the judgment of the Supreme Court, my lord, that for the reassessment.
Which one? Which one?
of the apex court judgment. You'll also find a DS copy. A2. A2 दिया ना साइकिल लाइट में वाली यहाँ पर दिया A2 ले दिया नहीं philosophy para 10 मिला
Paragraph
10 मिला
of Shyamdas.
मिला
Just a minute. This is AIR 1964.
division bench ले जाना ओके division bench division bench तो आओ
Constitution bench,
मिला
paragraph 4,
para 10 मिला
para 10.
May I read, Miller?
Please.
The next question is whether a turnover could be said to have escaped assessment if proceedings in respect of the first assessment were pending and the final order of the assessment was made therein. No assessment so and so. In so and so, it has been held. Income had not escaped assessment if there were pending of any time proceedings for the assessment of the assessments income, which have not yet been terminated in a final assessment thereof. This dictum of breakdown is clearly understandable principle. How can an escape of a turnover from assessment be predicted before the assessment is completed? The judicial committee in so and so, income tax commissioner so and so, relied upon the dictum of the rejecting the contention of the country raised by the SSC, they for him, and endorsed the said view. That decision turned upon the interpretation of section 34 of the Indian Income Tax Act. There, Bond and Company and unregistered firm made a return of the total income on so and so. On so and so, the income tax officer made an assessment of the return and company, the partners, whereas income tax officer, whereas the purchased the business of the Bond and Company in respect of the combined income returned by so and so. The High Court held that under the Income Tax Act, the income of the firm could be aggregated and that the income of the said must be separately assessed. Therefore, on so and so, an assessment was made of Bond and Company on the income as returned by them on so and so. It was contended that the Income Tax Act, it was not competent to make any assessment to tax after the expiry of the year for which the tax was charged, except in the cases provided under section 34 of the Act, that is what made reassessment. It was said by the judicial committee that the income of the Bond and Company had not escaped assessment within the meaning of section 34 of the Act. It was observed as agenda. If an assessment is not made on income within the tax year, then that income
they submit has escaped assessment within that year and can be subsequently assessed only under section 34 within the time limitation. This involves reading of the application had escaped assessment as equivalent to the has not been assessed. Then lordship cannot assent to the reading. It gives too narrow a meaning to the word assessment and too wide a meaning to the word escape, that the word assessment is not confined to the statute, to the definite act of making an order of assessment appears and from section 66, which refers to the cause of an assessment. To say that the income of so-and-so, which so-and-so was returned for assessment and which was accepted as correctly returned, though it was erroneously included in the assessment of so-and-so, had escaped assessment, seems to be to the lordship an inadmissible reading. The fact that the section 34 requires a notice to be served within calling for the return of the income and on which has escaped assessment strongly suggests that income which has already been duly returned for assessment cannot be said to have escaped assessment within the section 34. So, my lord, till the return is submitted, till the assessment is completed. Now, under this act, under section 22, my lord, the self-assessment was not there. Now, presently the self-assessment is there. If the self-assessment is completed, section 14 can be taken the cost to. But if the assessment is not completed, either in the section 34, 35, 36, 37, then the income cannot be said to escape assessment and reassessment proceeding cannot be initiated. Now, following this judgment, my lord, division bench of this on the court.
But this matter, don't you think it's in a slightly different footing? Here, the emphasis on the completion of the assessment.
My lord,
It
you
says that
said-
if it is not completed, then you cannot come to a finding that something has escaped or not.
my lord, in that time, my lord, the self-assessment was not there. So the question was that assessment has to be completed. Now, in this case, my lord, self-assessment has come that you submit the return in time, it will be self-assessed. Now, that's why it said, my lord, 34, 35, 36, 37. Now, if it has not been assessed at all under 34, 35, 36.
That point we have understood.
So, my lord, the by
The
question is that
application of this constitutional bench,
without there being any assessment, either 34, 35, 36.
we are clear.
Assessment
That
cannot
we have to seek their views. Otherwise, we have understood.
And the small one paragraph by following the Supreme Court judgment, my lord, the reassessment order was set aside.
It is the same case.
Same case, my lord.
Why the name has changed? From Shyam, it has been named Ghanshyam.
Well, there's reference is the same 51 ITR.
ITF 51. Shyam has become Ghanshyam.
Well, that is, the lordship knows, my lord, that
We don't know anything.
the division
We-
bench,
We used to know when we are that side. Now we do not know.
the division bench, which had passed the order, my lord,
Not know now.
Shyam became Ghanshyam, my lord. And if you also looks at this, the plea in the, my lord, affirmative question,
Hmm,
affirmative question which has been filed, my lord,
okay. Hmm.
at page 3, my lord, A.
Just a minute. By Raman Kumar Varman.
My lord.
Page 3.
Page 3, my lord.
Hmm.
P, your lordship may see, my lord. On the B, they are saying that they have not raised any objection.
Just a minute. Yes. See. To dust it for the. Yes, then.
The C they are saying, Lord, the conditions they've mentioned, 1, 2, 3, 4. Then in this particular case, the dealer has filed return as per section 29 and admitted the turnover and tax which concerns self-assessment and the ensure the necessary condition for turnover discrete assessment proceeding under section 40, which is not covered and time barred by section 39 of the Assam Value Tax, as assessment can be made after the expiry of 8 years up to 31 so and so. So they are not saying anything about section 35. You also see in the bottom, the opponent deny the condition, the contents of the respondent that the assessment has not been made and the precondition for infraction section 40 did not exist because as per section 35, submission of the valid return and payment tax confirms self-assessment and the self-assessment is also an assessment so and so. Now they are not saying about anything which I've said that the tax was return was not submitted in time, the tax was not paid in time, about they are not saying anything. Section 35, everybody knows that what are the conditions. If those conditions are fulfilled, the assessment will be completed. But they have not denied the submission made in the petition below that the returns were submitted on this date that will below the after the below the chart, both the charts, they have not denied.
Mr. Bhuya,
Lordship, can it be taken after 10-15 minutes, if possible? Because B. Guba is on next.
today is very crucial. Today, second half, we will probably not sit.
Lordship,
There is only a judgment. There are a lot of pending work before we leave.
Lordship,
Also, is not available next week.
Next 2 weeks. Some things have to be removed from the table.
Lordship, I'll express the urgency, Lordship.
Try to have him here in the first half.
Lordship.
After a while.
No,
মই এনেকুৱা এখন আনিব লাগে ৰুলছ থকাখন বা ৰুলছ বেলেগকে আছে নেকি ইয়াৰে ৰুলছত আহিব লাগে যোনটো অকল এক correctly হলো পিছত আনি থব পাৰিলে yes Cool. No, আহিব লাগিব না তেখেত অৰ্ডাৰ কি দিম নেক্সট
also we take up item 4 now. Also we're taking up item 4.
This is not the same matter we have heard.
No.
Same matter.
Competition Commission. Last month was.
But why was it adjourned on the last occasion?
No complete arguments were given.
No, it was adjourned on behalf of Sri J. Sharma.
Last occasion you also heard about for 1
I think that's
hour.
That will be the order prior to the last one.
Prior, it said that Justice, Honorable Justice Deka had heard the matter. No, we remember hearing this, but there is no indication in the order. Why?
Only you also fix that for the date middle only.
That's correct.
Today, it may not be possible.
It will take some time below also because
Said ask, it may not be possible today.
what you are
Sir, luck on next event. We'll fix it on Tuesday itself, it's a hearing day.
Very well.
Because in the first time, I don't think he'll be able to comment. But otherwise, we find it a very interesting matter.
My lord, lordship may fix it because your lordship has heard it at length, my lord, about 1 hour.
No, no, it will not be proper.
So your lordship may fix it after your lordship, my lord.
No, they have got some urgency, I think.
We do have some urgency.
There's an interim order also.
That's correct.
Again, I have to, my lord, your lordship has applied a mind also.
Otherwise, also today we'd have started from not from the scratch, but
But
now whenever we start, we'll have to start from the facts also.
I think, my lord, how many days it will be?
Paucity of time may not permit the matter to be taken up for final disposal today. What's the? Dr. Saraf, the learned senior counsel for the petitioner. Whereas the competition commission is represented by Sridas.
Yeah.
Sridas, Sri J. Sharma, learned counsel is present for response. Who is respondent to? Who? Your complaint.
It's one of the informants. Assam Real Estate Infrastructure Development Authority.
Okay, for respondent number 2, full stop. Sarah, since urgency has been expressed and keeping into account that there is an interim order operating, please to release this matter for admission hearing on Tuesday next. Date to deliver.
My lord, get to my lord, yeah, I have again repeating, my lord. Lord, within 10 days, nothing is going to happen. Your lordship may once returns. my lord.
2 weeks, we are not here, sir.
2 weeks, my lord, so many dates are there.
Let you try and make a mention.
Because your lordship has heard and applied mind, so I think, my lord,
Not keep a matter,
I don't want to part it, my lord, you'll get you fixed accordingly so that it may be taken up. Again, my lord,
try on Tuesday. If it comes to our bench automatically, then
how it will come on Tuesday, my lord, should not come.
later on, not now we cannot fix.
Actually, I do agree with Learned
So
Senior.
you don't want to have a matter tagged with a particular bench.
2 weeks, my lord.
And we are not here for 2 weeks. Had it been 1 week, doesn't matter. 2 weeks.
My lord, he's agreeing, so lordship fix after 2 weeks. It automatically come. 23rd, my lord.
Then last weekend, since urgency of no. As agreed to by both the by the parties, list for admission hearing on
23, my lord, Tuesday.
on 23rd. Okay, 23rd. 23rd is okay for you? 23rd.
The matter,
5.
substantial time was actually spent, Your Honor, before explaining the matter, so.
Let us, but we'll have to hear from the facts again. Will not take much time. But
My lord, I'm obliged. Interim order may continue.
interim order passed earlier to continue till the next date of list.
I'm obliged, my lord.
Next.
If you.
Yes, instructions.
Not as yet, not received as yet.
Get the instructions. Earth 3M secure Learned counsel for the petitioner. Also. However, it appears that instructions are yet to be obtained. Also, on the prayer of MS.S. Sharma, Learned State Council, as well as MS.N. Bodler, Learned Standing Council Revenue. Matter stands adjourned by 2 weeks. 2 weeks,
Lordship, I pray for an extra copy.
2 weeks to enable the Learned Council, to enable them to obtain instructions. Sri Sekya, the Learned Counsel for the petitioner, is directed to serve an extra copy to MS Bodler.
Extra copies were not served. That's why the delay, Lordship.
MS Bodler, the Learned Standing Council Revenue.
Obligation, Lordship.
I please, my lord. This is an eviction matter, my lord. Let me just cover the decision of this honorable court. What had happened, my lord, 6 writ petitions were filed by different petitioners on similar causes of action. The other 5 writ petitions got dismissed 3 years ago, my lord. This one somehow got segregated from the lot, my lord. I'm giving the list of the other cases and the similar orders.
Lordship, I have the instruction to appear in this matter.
Similar orders, my
Similar
lord,
order.
and the other 5 cases, my lord, I've given the list.
Heard MS F. Ahmed. learned counsel for the petitioner, whereas the respondent railways are represented by Sri B. Sharma. Full stop. Para. The subject matter of this writ petition is against an order passed, an order dated 19/10/2019, passed by the learned additional district judge number 1, Kamrup within bracket M, in Miss Appeal number 21/2017, whereby the appeals filed by the petitioners have been dismissed, has been dismissed. Full stop. The appeal was referred against an order dated 21/3/2017, passed by the learned estate officer,
Estate officer.
under the provisions of the public premises within bracket eviction and unauthorized occupation bracket close act, 1971. Full stop. The para. MS Ahmed, the learned counsel for the petitioner, submits that the relevant factors, including the fact that the petitioner was residing on the land in question for about last 65 years, have been grossly overlooked. Full stop. On the other hand, while supporting the order passed by the estate officer as well as the learned additional district judge in the appeal, Sri B. Sharma, the learned counsel for the railways, has submitted that cases filed on identical facts by similarly situated persons before this court against under similar circumstances have been dismissed. Full stop. He places before this court two orders dated 2/12/2019, passed in WPC 8875/2019, and 6/12/2019, passed in WPC 8937/2019. Full stop. He submits that there were 5 cases in total, and only the present case was somehow left.
Including this one, 6, madam.
There were 6 cases in total, and somehow the present case was left out. Full stop. Left out, and all the other 5 cases have been dismissed. Full stop. He accordingly submits that following the aforesaid decisions, the present writ petition is also liable to be dismissed. Full stop. MS Ahmed, learned counsel for the petitioner. Last one. Sri Sharma also submits that the same set of counsel were also there in the other 5 writ petitions. Full stop. MS Ahmed, the learned counsel for the petitioner, fairly submits that it is a matter of fact that 5 other similarly situated writ petitions have been dismissed by this court. Full stop. In view of the aforesaid facts and circumstances, and following the decisions rendered by this court in similarly situated writ petitions, the present writ petition also stands dismissed. Full stop. Further, following the observations made in the other cases, it is provided that the petitioner be given 6 months' time.
They've already enjoyed it for more than 3 years now, my lord. We require the land urgently for some developmental works, my lord.
No,
Some-
1 month.
Lordship, can it be for 3 months, Lordship?
No, don't write anything, at this stage, it is pointed out on behalf of the petitioner that in the other cases, comma, 6 months' time was granted to petitioners in those cases to vacate the land, and a similar direction may also be issued, full stop. Three, para, three, Sharma, the learned counsel for railways, however, submits that the petitioner are already in possession of the land, in spite of the fact that similarly situated writ petitions were dismissed way back in the year 2019. Court of he therefore submits that there is no justification to ask for more time to vacate the premises. Full stop, para. Be that as it may, comma, and be as it may, and in the interest of justice, a further period of 45 days is granted to the petitioner from today to vacate the premises in question. Full stop. The petitioner is to ensure that within within 45 days, comma, the vacant and peaceful possession of the land is handed over to the respondents.
Much.
Mr. Gogoi. Pick it up from you.
Here, one thing I'd like to point out, my lord, while preparing the case, my lord, this has come to my knowledge. In fact, same query Lordship has posed to my lord, raised now, my lord. Page 92, my lord, the assessment order says, my lord, it has been audit assess. The dealer was selected for audit assessment under section 36 of the VAT Act. Whereas in our affidavit or stand is that, my lord, the entire assessment was done under section 35.
35, self-assessment.
So, some, my lord, discrepancy in these two stand, my lord. In assessment, it is 36, or affidavit, it is 35.
No, the thrust of the argument made on behalf of the petitioner that if you take 35 into consideration, 35 prescribes a certain mode.
Lordship.
And by taking us to the chart, the contents of the chart, it is submitted that 35 requirements have not been fulfilled.
Lordship.
So self-assessment as such per se cannot be invoked. So if 35 goes, then the entire basis of reassessment
Goes.
will not be there because other sections are not attracted.
Lordship.
As per your stand. Now, if you say that audit assessment was there, then there is a different section because it encompasses 4 sections.
I know, I understand. Yes. It is under 39 in that.
39 is also covered under.
He said that only it was selected, not completed.
Yes.
It was selected only. And if your lordship sees rule like 21, it says if it is selected, no self-assessment.
Not assessment.
And then it says that no self-assessment.
No.
You
then
take the
it is not
instruction, you
set.
take the instruction.
In fact, my lord, under section 40, the limitation is some 8 years.
Yes.
But my lord, section 35 and 36 comes under, my lord, section 40.
No, there is no dispute. There are 4 sections
My lord.
which 40 takes care of. But you need to fulfill the 4
Yes.
sections because 40 is an exception. If you
Lord.
come to the prior section, the things gets over.
My lord. In that case, my lord, lordship will post it on next week on that point. Otherwise, my lord, I would pray, my lord, lordship will in that case remand it.
Just see below rule 21. Rule 21.
Let him take the instruction.
No, Lord, it was said is selected for your lordship.
No, we have understood. Selection is not.
It says specifically, my lord, except the
Select-
cases selected for audit assessment.
Yes.
Hard
22.
Dr. Saraf, the learned senior counsel for the petitioner, who submits that the action of the respondents is prima facie without jurisdiction, inasmuch as the pre-requirements of invoking section 40, namely that the assessment has to be done under section 34, 35, 36, or 37 is not fulfilled. Full stop. He further submits that it appears that in the instant case, such invocation has been done by assuming that the assessment was done under section 35. Full stop. By drawing the attention of this court to the contents of a chart prepared on the aspect of self-assessment under section 35 of the Act, the senior counsel submits that there are certain requirements of self-assessment as laid down in the subsections, and admittedly, those requirements were not fulfilled, and therefore the assessment cannot come within the meaning of section 35 of the Act. Full stop. He accordingly submits that when none of the sections mentioned in section 40 are applicable, the authorities cannot take recourse of section 40, and therefore the present challenge has been made. Full stop. On the other hand, Shri B. Gogoi submits that there appears to be some inconsistency with the stand of the department in the affidavit and the documents. Full stop. He elaborates that while the affidavit states that that section 35 has been sought to be taken into account while exercising jurisdiction under section 40, in the document of the department, there is a reference to an audit assessment. Full stop. So Dr. Saraf, the senior counsel, however, submits that the said reference will not make any difference as per section 21.
Rule 21.
As per rule 21, we don't have the rules. What is the exact language?
But that if the assessment is selected for
That selection for audit assessment is not,
no, Milord, it says, Milord, that if it is selected for assessment, then no self-assessment.
no,
No self-assessment shall be deemed to complete, except the cases selected for audit assessment under Rule 22. All cases shall be deemed to have been assessed under subsection 1 of section 35. So if the case has been selected for audit assessment, self-assessment will also move.
Dr. Saraf, senior counsel submits that rule 21, that if the version of the department is considered, the same would be in favor of the petitioner in view of the provisions of Rule 21 of the rules of 2005, Assam Value-Added Rules of 2005. Full stop. Be that as it may, Shri Gogoi pays for some time to obtain appropriate instructions in this regard. Full stop.
Direct them to, if audit assessment is there, to produce before the court.
Yes.
Appropriate instruction in this regard. Full stop. In that view of the matter, list this matter on, we'll have it on Thursday next.
Lordship.
23rd, Milord.
We'll have it on 11th.
Your lordship will not be there.
No, there will be benches.
But your lordship will heard it lengthy.
No, we have not heard.
23rd, Milord, it is almost complete.
We have not heard. We'll forget everything.
Your lordship may not make it part of the 23rd, Milord. Unless it's almost over, Milord. It means only instruction that whether audit is.
We will not have time. 23rd, we have fixed the other matter.
The 24th, Milord, any date.
25th.
25th.
25, 3 weeks, we will not remember anything.
Milord,
We have it on 11th. If there is anything, you get it postponed.
Unnecessary, Milord, again, the problem will be there. Your lordship may fix it on 25th. We'll remind it when your
It will not be proper. On 11th, on which date we would also produce the records pertaining to the instructions.
Lordship.
assessment is there. They can produce it.
If it comes automatically, we'll take up. We'll not.
2 weeks, Milord, lordship going to Anachal, Milord, that is too far, Milord. I'm obliged, Milord. Interim order may continue, Milord.
Interim order passed idea to continue till the next day of listening. Next. 7.
Well, we have filed an affidavit regarding
Justice Service, my lord, about the respondent number 5. So here,
No, my lord, I am for, my lord, private respondent, that is 7 to 13 member, my lord.
No confidence matter.
no confidence matter.
Yes, what is it? Oh, Dusty has been affected.
No, my lord, he refused
Refused.
to accept.
Have you stated this on affidavit?
Yes, lordship.
Paragraph 2.
Yes, lordship. Paragraph 2.
Who has filed the affidavit? Fulbright petitioner.
Yes, lordship.
How we verified section? To the best of your knowledge, okay. Yes, we'll accept this. Yes, you want to proceed with the matter?
Yes.
Yes, what is it? Yes,
Today, my lord, my seniority on
Let me fix for admission, my lord.
now if you want to proceed, you could have proceeded. No confidence matter. The term is otherwise expiring very soon.
What date will be given, my lord?
You are challenging on what grounds?
They put. They put us.
My lord, the original has not been sent, but what has been sent is the Paravise comments along with the relevant documents, copy of the relevant
No,
documents.
no, let us try to know what are his grounds of challenge. On
15
what
days,
grounds?
15 days was not
Given to the president.
given to the president, my lord.
When was the notice issued?
Notice issued on 18/12/2020, my lord, page number 14,
14,
lordship.
1/4. Yes,
And without placing the matter has been
1/4. Let us come to 1/4. This is the communication to the secretary
to the secretary, my lord.
for no confidence.
Lordship.
Mark to the president also.
Okay, full ball. Okay, now this is 28/2,
22, 12,
28/12, 21,
2020,
2020.
lordship.
Then
2, 3, 4, 5.
you received the notice?
No, my lord,
Not received.
not received, my lord.
But he refused to accept, my lord, as per my instruction.
No, my lord.
Or refused to accept is not.
My lord, date, please, my lord,
It was
I
not
think
placed
definitely.
before the petitioner, my lord.
Because, my lord, fine, refused to accept, my lord, the secretary referred to the Anjalik Panchayat.
Your name is Ahmed. What is your name? H.A. Ahmed.
HM.
Mr. Ahmed, not received and refused to receive are two different concepts. If you refuse to receive it, then it will amount to receiving.
Yes,
But if it was not served upon you, then you may have a case.
Not sub, my lord.
Not served.
Without submitting, my lord, the 15 days counting from the date of reference 28/12, it was referred on 12/1/21 to the answer concept. At page number
12/1/21 referred to Anchalik Panchayat.
perfect.
28, 29, 30, 31. Then also it's 15 days.
As per my record, my lord, the.
But when was it referred to, serve upon you? When did you come to know about the proceeding for the first time?
Lordship. Can it be taken after some time, my lord?
Now we'll pick it up. What is the problem in trying to get some exposure? At times, there will be a time when you need to stand up and argue. Are you asking some very difficult question? We're asking factual questions.
Lordship.
File is with you. Where have you stated regarding receipt of the notice? Which date, first time?
I have not received, my lord.
You don't, when did you know about this no confidence? When did you come to know about this no confidence motion? When was it passed? No confidence? When was it?
It was possible at one,
21.
16-1.
2021. There is no interim order.
No, my lord.
In para five, it's
Then
petitioner.
why are you fighting now? We are in the end of the term.
Yes, my lord.
24, I think it'll be over. Or 23.
2020. Yes, my lord.
When? 19, I think 19 you took for the first meeting was held.
Yes.
19, 20, 21, 22, 23. I think end of 23 matter would be over.
December.
In every case, my lord, I see the president always take that plea, my lord, that I have not received the notice and no governance is passed. No member is with him, my lord. So suppose for a moment we presume, my lord, that notice would have been received, even then he has no case, my lord. Still now, 7 member, my lord, containing their job, my lord.
Representing 7 members of members.
Yes, my lord. 7 or
Senior is on legs in.
As per my instruction, my lord, the notice was served. And we have a note sheet, my lord. And a peon book also.
Is there an endorsement by the peon?
Yes, my lord.
He had refused.
It's written the peon book, my lord.
Fine,
সভাপতিয়ে চিঠি গ্ৰহণ কৰা নাই।
fine, yes.
That was mentioned.
Refuse to accept.
I think you should instruct your clients to have a videographed, because these are the most common
Yes.
defense that it was not served upon us. You have it videographed, it was standard, or have a stint operation with a hidden camera. The matter pertains to a no confidence motion against the petitioner, which was passed on 16/1/2021. Full stop. The primary ground of challenge is alleged violation of the provisions of section 15 of the Assam Panchayat Act 1994 regarding receipt of notice, full stop, para. On the other hand, both the Learned Standing Council for the PNRD departments, Sri Devnath, as well as here for whom? Mr. Uddin, here for whom?
But I'm from 7 to 13, ma'am.
As well as Sri Anuddin,
Yes, ma'am.
Learned Council for the respond number 7 to 13.
13.
Submit that dispute the said allegation and has submitted that the notice was tendered to the petitioner who had refused to accept, and therefore he cannot, therefore the petitioner is debarred from taking the ground of non-receipt, of non-serving of notice, full stop, para. Be that as it may, comma, Sri Ahmed, the Learned Counsel for the petitioner, has prayed for some time on the ground that his senior is not readily available, full stop, para. In the interest of justice, list after a week.
I'm obliged, ma'am.
So Pushilal, what is this?
In this matter, complete compliance of the order dated 22nd February was not done. Whether my name was removed earlier from the GEM portal.
Yes.
And thereafter, you are tasked protecting me, giving some interim protection.
Yes, blacklisting, yes.
Yeah. Thereafter,
Instructions.
Well, they have filed one affidavit, my
one
lord.
additional affidavit has been filed, your lordship. It's there, where we have stated that on one hand, they are saying that my name has been
Remove from the GEM portal.
on the GEM portal, but on the other hand, they have issued letters communicating to the successful bidders, where successful contractors, where they were asked not to take any help because I am blacklisted company. Your lordship, kindly this paragraph.
Now, Mr. Parashar, what is it?
My lord, yes, my lord, I have instruction today, my lord. My lord, in the affidavit, my lord, my lord, may see the, my lord, page 30.
Affidavit filed in which case?
File
Additional
in
affidavit.
the IA,
In the IA.
in the IA.
Yes,
My lord, page 30, my lord.
30, yes.
That is the order, first on 21st of April, my lord. passed by the same officer, Malat, Kanwar Jitendra Singh Malat, who passed that order, Malat, 24th of February, Malat. Last paragraph, paragraph 3, it is once again written that the headquarters so 24th February order stands null and void, recall, cancel. That is passed on, Malat, 21st of April. Malat, now, Malat, in the affidavit, Malat, they have annexed one, Malat, next page 31, Malat. This is a letter dated 14th of April. That is earlier to the cancellation, Malat. Earlier to the cancellation. Directed to the other bidder that they have to disclose that they have no communication with Mark Construction and Malat, Mark Transport and this Suresh Rai. But this is Malat subsequently. Malat today, Malat yesterday, in fact, Malat I have received Malat in fact para-wise comment to regarding this Malat. Here it is written that Malat, however, debarment letter that issued on 24th of February and cancelled on 21st of April. Context so. And Malat, as debarment letter of Mr. Suresh Rai has been cancelled, therefore affidavit asks by letter that is 14th April stands null and void cancelled. That is clarified. So and direct request me to file an affidavit.
My only submission is that since they have already cancelled, now they can withdraw these letters and give it on
But
record in the court itself.
no annexure and nothing has been given, only these 2 pages. Very
Will give you some time to take consideration.
Malat.
Chakraborty, since they have already,
I am for Jam, madam.
no, understood, since they have already cancelled, the meeting,
That clarification, that letter may be issued.
how it will be Puchila Learned Council for the petitioner who, by referring to the additional affidavit filed in the terracotta application as submitted, the petitioner is petitioner don't suppress submits that communication dated 14/4/2023 has been issued from which it appears that the prejudice caused to the petitioner by way of blacklisting is still kept in force in spite of the interim orders passed by this court. Full stop, para. 3. A.K. Parashar, the learned CGC, however, submits that while the document dated 14 April 2023 has been placed before, has been relied upon by the petitioner, there is a subsequent document, communication dated 21/4/2023 issued by the authorities, whereby it has been clarified that the earlier letter, that the impugned letter dated 24/2/2023 has been declared null and void and cancelled in view of the order of this court. Full stop. Para.
And a comments
has also submitted that otherwise comments have been
last 3 lines
sent, comments have been furnished to him.
First page, last 3 lines.
Containing a similar instructions. Full stop. The learned CGC has laid emphasis on the instructions to the following effect. Last, yes, as department inverted comma. Full stop. Para 3. B. Chakraborty, learned counsel for the GEM, however, submits that the matter, that the present dispute is something to do between the petitioner and the army authorities, and GEM is only the nodal agency. What's the para? Sri Pushilal, the learned counsel for the petitioner, however, submits that consequential action
I may be,
consequential action, which were direct, maybe has not been taken after the letter dated 21/4/2023. Full stop para. Sri Parashar, the CGC, accordingly, praise for and is granted 2 weeks time to obtain instructions regarding the steps taken.
they've already
For
clarified, my lord.
withdrawing the letter. Withdrawing-
Regarding the steps taken consequent to the communication dated 21/4/2023. You take instructions, what is it?
Your Lordship, can it be on 26th of this month?
Please after 2 weeks. We have kept your, this thing.
On record.
Is there any interim order?
There is.
Interim order passed earlier to continue till the next day of listing.
Actually, already they have stated, as per my, that I may be closed, they have filed for non-implementation of the interim order. We have cancelled that order,
We'll consider. And we'll go to the main dispute then.
Yes.
Obliged.
এইটোতো আমি সময় দি থৈছি 9 সময় দিয়া নাই ন এইটো 9 টো কত দিছিল ন মই ৰাতিপুৱা মেনশন কৰিছিল ন পিছত আহিব Mr. Das, which one?
Case, fishery case.
To-
I was ready. I've been told that KK Mohanto,
Yes.
senior, he is not well, I think.
And today we'll all also have some difficulty.
He is not well.
This code will not be available for 2 weeks. Tomorrow is a holiday. We have to sign some.
Oh, that's my lord,
We'll have it
after 2 weeks, your lordship.
after 2 weeks. Is it okay for you? We'll have it since we have heard substantially.
Yes, yes.
It's a part matter.
Hey, your lordship has heard this matter. Let it, your lordship,
Is hard, my lord.
your lordship will come back, then your lordship will take up this. matter.
Today, two times you have.
But the financial bit, there's a vast difference.
No, no, not only that. I've been told, because now onward, we can just hear it because it is already recorded. That's very nice for us. I was in some other court. 2 things which your lordship has stated, has said that whether they have to take some application of mine, because there indicate there is some order of this court in deciding, remanding the matter back to the government, whether it is required or not. One of the paragraph, on top paragraph, after 3 paragraph, government has applied his mind. And the last to last paragraph, government said, available on record, we find that this fishing experience certificate, caste certificate is available. But in pursuance of High Court's order, if you see on the top, they have taken some application of mine. But the amount, a huge amount, my lord, huge.
No, we have asked him whether there is no default. There is no default here.
No default. And secondly, there is a judgment of your lordship. There is judgment, we have taken the judgment which went to your division bench. I appeared.
Allegar.
Yes. The amount, see the difference of amount.
Okay. It is submitted that Sri KK Mohanta, and a senior counsel for the petitioner, is unwell today, full stop. This is item number
22, my.
2020. 22.
It's not partnered.
State, your lordship not willing to state it, but twice or thrice the matter was heard.
Agreed to by the, as agreed to by the parties, list after 2 weeks, let's see,
18, my lord.
list on. Okay, list on 18th.
For further hearing, your lordship can put.
No, we are not sitting for 18th. On 18th.
Sir, can it be on 20?
Huh?
Item number 9, 10 and 11, my lord, is a old matters, my lord. So it takes a date, my lord.
Don't worry. At 2 we'll be sitting, there is a judgment, I think. Orders to be pronounced.
No, item 19, my lord, may you date me.
He'll give a date. What is the matter, Mr. Das?
It is, we have 14 matter, my lord.
What is the matter about?
That is industrial dispute, my lord, termination of service.
You're for the workman?
Yes, please.
Order. though this order is a long one, I'm not reading the entire, but some paragraphs are required to be read. Sri Anantlal Gyani, while appearing before this court on 19/4/2023, has submitted that there was an email from the World Bank dated 6/4/2023, pursuant to which the work orders were issued to various parties for supply of the seeds. He had stated that such orders were issued on the next date, that is 7/4/2023. The aforesaid explanation is not at all justified inasmuch as the communication from the World Bank, or for that matter any other authority, cannot be used to violate a court's order, more so when the records reveal that the department was very much aware of the proceedings in the court and the restraint order. In any case, since an explanation was put forward, this court, by taking a broad view and not to cause any prejudice, had also examined the said explanation by examining the materials which were in original records placed before this court by the Learned Studying Council. However, when the records were examined, it was found that the work orders to the various parties were issued on 6/4/2023 itself. The director then explained that it was done after receipt of an email from an officer by the World Bank, which was of the same date, that is 6/4/2023. A perusal of the records revealed that no doubt there was an email of an officer from the World Bank. The same was sent on 5:04 p.m. on 6/4/2023. Therefore, if at all the version given by Sri Gyani is to be accepted, such orders are to be presumed to have been issued after 5:04 p.m. on 6/4/2023. In other words, the work orders were issued after the office hours. The copies of the work orders dated 6/4/2023 have been perused from the records, and the same reveals that all the beneficiaries had received their respective work orders on 6/4/2023 itself. The record contains about 17 such work orders of different quantities, which, if the version of Sri Gyani is to be accepted, were prepared, approved, issued, and received after 5:04 p.m. of 6/4/2023. It clearly appears that the justification sought to be made by taking the email dated 6/4/2023 of the officer of World Bank is a shield. Is a complete eyewash to wriggle out of the situation, which is absolutely unbecoming of an officer in the rank of the Director of Agriculture. It appears that the aforesaid recourse to mention a fictitious, there is another aspect. Yes. There is another important aspect of the matter which is required to be highlighted. As stated above, about 17 numbers of work orders were issued on 6/4/2023 to various beneficiaries. A bare look at any of the work orders would show that the order has been issued in reference to an email by the respective parties dated 6/4/2023. No such copy, print of such email is found in the records. More importantly, each of the supply orders refers to the beneficiary as the L1 bidder against an office IFB under reference. There is no such IFB in the reference of the orders, and the number of such IFB in the body of the orders have been kept blank. The records do not indicate that there has been any such IFB. It appears that the aforesaid recourse to mention a fictitious IFB in the work orders by the director is only to give an impression as if there was a recognized procedure of tender which was followed. The aforesaid observation of this court is fortified by the use of the expression L1 against all the beneficiaries to whom the work orders have been issued. Even for the sake of argument that all the benefit of doubt may be given to the Director of Agriculture regarding his explanation of the instruction from an officer of the World Bank, supply orders could not have been issued at the whims and caprice of the director without following an established procedure of law. The said supply orders dated 6/4/2023 are expressly illegal, apart from being in violation of the direction of this court. Then we have dealt with the leave issue. We have dealt with the contempt provisions, the case laws. This court is of the firm view that the very objective of the contempt of courts 71, read with Article 215 of the Constitution of India, is to maintain the dignity and majesty of the institution, which is the guardian and sentinel of the rule of law. Apology cannot be used as a shield to purge the guilt. The facts and circumstances of the instant case would lead to an inevitable conclusion that the action of Sri Anantlal Gyani was a willful and deliberate disobedience of the orders of the court. The violation is not of one order, but of a series of orders, and in fact, the said violation has been categorically admitted by the incumbent. In the oral explanation, the incumbent has said that he did not understand the implication of the order and there was some miscommunication and misconstruction. Such explanation from the director, who is an officer in the cadre of the Indian Administrative Service, is not at all acceptable. As has been held earlier, the so-called justification taking the shield of an email by an officer of the World Bank is absolutely an eyewash and is not acceptable. Though from the facts and circumstances, Sri Anantlal Gyani is prima facie guilty of contempt of court, this court, after much deliberation and keeping into account the age and career of the incumbent has decided that as an exceptional case, the apology tendered by the officer be accepted. Even though this court has decided to accept the apology tendered by an affidavit by Sri Gyani, the seriousness of the matter cannot be overlooked. Accordingly, this court directs the appropriate authority in the Department of Agriculture, namely the Additional Chief Secretary in charge of the Agricultural Department, Government of Assam, to look into the following aspects, rehearse the ground of the action being in violation of the court's order. Number one, how about 17 numbers of work orders were issued on 6/4/2023, which have been stated to be pursuant to an email of an officer of the World Bank received on 5:04 PM on 6/4. When the aforesaid email of 6/4 was not addressed to this Sri Gyani, the director regarding the supply, how could supply orders be issued on a telephone instruction of a market analyst of areas as stated by Sri Gyani? When the approval of the state project director was conveyed to the director only on 10/4/2023, how could the work orders be issued on 6/4/2023? Though the work orders refers to an IFB and has termed each of the beneficiaries as L1, when the records do not contain any materials of any such tender process, how could the work orders contain such statements? How could an order be passed on 10/4/2023 by Sri Gyani cancelling the work orders when he was on leave on that date? Therefore, said aspects are to be examined in a meticulous manner, giving paramount importance to the seriousness of the matter, more particularly the aforesaid point number 4, where apparently fraud was resorted to circumvent and overreach the orders of the court. To facilitate such an inquiry, the department may explore the action of putting Sri Anandlal Gyani, the Director of Agriculture, under suspension, or at least transfer him immediately, so as to ensure that the inquiry can be done in a transparent and impartial manner without there being any attempt to tamper with the records. The aspect of the matter pertaining to violation of the code having been dealt with, both the writ petitions will be listed for admission after a week, as the subject matter would require expeditious disposal.
Lordship, the record.
Records, yes, records are. I think we have written here. The records are, yes, the records are returned back to Sri B. Chaudhary, Land Standing Council, Agriculture Department.
Government will submit a compliance report, my lord.
On this.
That will,
Otherwise, my lord.
that will explore.
In the day,
because-
my lord, some message has to go.
Go,
We are not personally not against anybody.
Clear.
System has to function in a.
Otherwise, my lord, this order, my lord, there will be nothing how this has been complied with, my lord. There will be nothing to show, my lord.
No, the resort to, tentatively we have said resorting to fraud, we will not accept. We can accept anything in the court, some days for disobedience, apology, but there's a fraud, IFB has been stated. Each beneficiary L1, where is was the procedure? There's no procedure. Let us see, because this court will not be there for 2 weeks, so we had to,
My lord.
we did not want to keep this hanging.